Hey guys, welcome to our video. My name is John Watts. I'm an Alabama consumer protection lawyer. And I want to talk to you today about the concept of bankruptcy discharge debt. And so I was at court today and I'm home now. And obviously I didn't wear this when I was at court, but something came up about bankruptcy and discharge debt. And I thought it might be good to have a video kind of doing an overview of it. And then maybe we'll do some more specific videos and we'll look at some case decisions where courts have addressed what happens when you discharge a debt, but then the original creditor or a debt collector comes along afterwards and they start collecting that debt. So first of all, what in the world is discharge debt? Well, it's typically when we file a Chapter 7 bankruptcy. And then a few months later, we get what's called our discharge orders. Piece of paper, it says all the debts that are normally discharged are discharged. In a way, seems kind of silly, but the point of that is basically all the debts you list in your bankruptcy will be discharged with some exceptions. So for instance, a student loan, you have to take some specific action to get that discharged. Very hard to get it discharged. But just in normal terms of medical bills, credit card, mortgage loans, car loans, whatever, those are discharged. Now, you can reaffirm the debt, which means that you agree to be bound again by the debt, but we're not talking about that here. And we're also not talking about, in this video, what happens if you discharge your mortgage loan, but you're still in the house. Can they foreclose? Can they not foreclose? Here's a simple hint. They can foreclose as long as they follow the rules. So you discharge the debt, but not the security interest in your property. But again, we'll put that aside for a different video. I just want to focus in on, let's say, a credit card debt or medical debt that you've discharged. No doubt you discharged that debt, okay? So you listed that in your bankruptcy petition and notice went out to that creditor or that debt collector. And after the discharge, when you're supposed to go, oh, finally, okay, I get my fresh start, I get to start all over, now you get the letter saying you owe this money. You get the phone call saying you owe this money. You pull your credit board and you look and it's got a current balance of $5,000 on a debt that's been discharged. What do? Well, that discharged debt means you are never to have to worry about that debt again. You could think of it like out here is the debt and here I am. In between the debt and me is this wall that goes up to infinity and down to infinity and to the right infinity and left infinity, and that debt cannot come through that wall. Whether it's the original creditor or the debt collector, it just cannot get to me anymore. That's the fresh start that I get in bankruptcy. But it won't shock you to know that sometimes these companies break the law. They don't follow the law. They go, let's see, I could collect this debt, make a bunch of money, or I could follow the law and not collect the debt. They go, I think I'll collect the debt, because probably the consumer won't do anything about it. And if they do, they probably won't be able to find a lawyer to help them. And if they do, we probably won't have to pay any money. We'll just say it was an accident, it was a mistake. And even if we get hit, it's very unlikely, and we'll make a whole lot more money collecting than we will pay out in attorney's fees and damages. So if you get that call, you get that letter, first thing is check your petition, your bankruptcy petition. Make sure they're listed on there. So if it's Discover Card, if it's a hospital bill, whatever it is, make sure they're listed. If they're not listed, it probably is still discharged, but that's a little more complicated question. So we're going to stick with if it's on the petition. Well, then you get that call, you get that letter. You have a choice to make, and there's no right or wrong answer here. One choice is, boom, you just sue these guys. Okay, you sue them right away. If they're a debt collector, you sue them under Fair Debt Collection Practices Act. You sue them under a discharge violation. If it's original creditor, you sue them under discharge violation. So that's one option. Sometimes courts say, well, I really wish you had given them a chance here, a chance to fix it. And I get that. I get that. But a lot of times, that's what we do. We sue them. And here's how it typically goes. So imagine it's an original creditor. We discharge it, and then later a collector writes us a letter, calls us. So I'll sue that collector. And every time I get the phone call from their in-house lawyer or whatever lawyer's representing them, they'll say, John, we didn't know. You didn't warn us. We can't be at fault for this. I mean, we didn't know we were breaking the law, so you got to let us go. And I go, seriously? You didn't know that this was discharge debt? They go, no, we had no idea this was discharge debt. I go, man, today is your lucky day. You are completely off the hook. And they go, really? Seriously? I go, yeah, I just need you to do one little thing for me. I need you to write an affidavit. I might need to take your deposition because I need your testimony where you throw that original creditor under the bus. You say, man, that original creditor never told us it was discharged. They told us this was valid debt, fully collectible, not a word about discharge. And show me your contract between the original creditor and you, where the contract says the original creditor swears they'll never send a discharged debt because, man, we are going to butcher that original creditor in court, and you're going to be my star witness. They go, well, now, John, maybe we could work this out. You know, let's not get all worked up here. Let's try to settle. How much do we need to pay you? I go, no. I don't want your money because you're totally innocent. I want the original creditor that set you up for this. Of course, what they're thinking is, oh, wait, I'm going to burn the original creditor who sends me 5,000 accounts a quarter or 500,000 accounts a quarter. Yeah, they don't tend to do that. But there's another approach, and that is you give them a warning. So you call that collector, that original creditor, you write them a letter and say, hey, this was discharged. Don't ever bother me. Don't ever do anything. Don't have this on my credit report with a balance other than 0 that says discharge in bankruptcy. I just need you to fix this. And if they fix it, then they get off the hook. And if they don't fix it, then you sue them, and now it removes that excuse about, well, we had no idea. Now, sometimes what they'll do is you'll say, hey, this was discharged. They go, you have to prove it to us. Go pull the entire bankruptcy petition. I want you to mail it to me, and I want you to do blah, 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 all this stuff. And at some point you go, well, wait a minute. Why do I have to do your job for you? You're supposed to make sure this is good debt before you start collecting. I've now disputed this. You're supposed to go verify. I've told you it was included in bankruptcy. Why don't you go to the bankruptcy court and look at this? Because it can get to the point where it feels like, what's that game at Chuck E. Cheese, Whack-A-Mole, where you got the little stick and all the holes in the mole pot. You whack it, and then it pops up somewhere else. And you whack it. Because what can happen is a collector comes after you and you say, hey, this was bankruptcy, and you mail them a package and all this stuff. And they go, okay. And then they send it on to the next collector who collects against you. You go, hey, this was bankruptcy. You go, prove it. You send on the package. So you're dropping, $5, $10, whatever it is, and taking all this time. And it keeps going from collector to collector. Well, at some point, you need to find a collector or even the original creditor that you can kind of grab a hold of their throat and say, wait a minute, we're not doing this anymore. And we're going to kill this debt that sort of springs back to life. We're going to kill it, and I'm going to kill it through you. And look, here's the deal. Sometimes, whether it's discharge debt or just a debt that you don't owe in some other form or fashion, you sue the bad guys, and they pay you money. And then a year later, they come back like you never sued them in the first place. And you know what you do with that? You sue them again. And then they pay you money, and 18 months goes by, and they come after you again. You sue them again. I had one client that it wasn't quite discharge debt, but it's pretty close to it. And probably every 18 months for about maybe 4 or 5 years, like the same company would come back to us, and we'd sue them. It was kind of a joke. He'd call me and say, hey, I'm kind of wanting to go on a really nice vacation. Isn't it time for them to break the law again? I'm like, probably so. And if they want to break the law, I view that as sort of a cry for help, that they desperately want to pay you money. And hey, who are we to stand in their way of paying you money? All right, we're going to help them out and let them pay you some money. So if you're dealing with discharge debt, and let's say you sue the bad guys and they pay you money, and then a year later they come back, I guess they want to pay you some more money. So, that's okay with me. I assume it's okay with you. So keep that in mind. Discharge debt, we'll go into some more videos where we kind of break it down step by step, but we're talking about any collection efforts on discharge debt. So calling you, writing you, calling your neighbors, calling your coworkers, sending forms to your employer about, hey, we want to garnish you, suing you. That would be a problem if it's discharge debt. And on your credit report, anything other than a $0 balance, and it should say in the comments, discharged in bankruptcy or included in bankruptcy or something to that effect. And if there's a balance on there, you may want to dispute that through the credit bureaus. Again, a lot of this depends on, we're talking about an original creditor that's not subject to the FDCPA, or is it a debt collector that is subject? And if it's an original creditor, do you happen to live in a state that has a good law that basically takes the FDCPA and applies it back to original creditor? So Florida, for example, will do that. And so anyway, I hope that this is helpful to you, and that you learn some stuff about discharge debt, because I tell you, it's very frustrating. Nobody goes into bankruptcy that I've ever seen with sort of a flippant attitude, like, what's the big deal? I'm just going to file bankruptcy. Now, people are torn up about it when they file it. They're filing because of medical debt, some crisis, loss of job, or divorce. That's basically why people file bankruptcy. And to finally go through all that and you're done and you go, okay, now I get a fresh start. And then your phone rings and somebody collecting that discharge debt or a letter or your credit report. It's incredibly frustrating. And so these guys do need to be sued when they do that. So if you have any questions, specific questions, reach out to me privately, alabamaconsumer.com. But just sort of general questions or thoughts or your own experiences, feel free to put those below in comments. And we'll do more videos on discharge debt. If you want to make sure you're notified about those, just click the subscribe button. And I appreciate you watching this, and see you guys in the next video. Bye-bye.